All right, we're looking at two pieces today that discuss the relationships between Islam and law in two different places, in Iran and then in Morocco. So we're starting here with this piece by Sayyid Amir Arjomand, Constitution Making in Islamic Iran, the Impact of Theocracy on the Legal Order of a Nation State. All right. Arjomand opens with reference to Weber, Max Weber, on the the rationalization of sacred law, saying that it remains substantive in character. So, what does this mean? Weber explains substantive law as a type of law which is most appropriate to the expediential and ethical goals of the authorities in question, who are not at all interested in any separation of law from ethics. This is particularly true of theoretically influenced legal systems, theocratically influenced legal systems, which are characterized by a combination of legal rules and ethical demands. Right? So that the idea here then is that substantive law has this notion of expediency attached to it, and expediency with respect to what? Well, with respect to achieving the goals, in particular the ethical or moral goals of the authorities establishing the law. Arjomand points to early attempts, so pre-revolutionary attempts in Iran to incorporate Islamic law into a state structure. These largely failed, right? They ran into specific kinds of problems and wound up more than anything producing this kind of dual legal system of secular law on the one side that was the purview of the state, and then religious law on the other. Judges' law was the law of the administrative state then, right? So that courts, judges, and the state were all on the one side, and this included administrative law, fiscal law, criminal law. Sacred law, on the other hand, became the purview of jurists, that is, experts, academics, religious figures, not judges. The theoretical supremacy of Sharia, so Islamic law, remained unquestioned, but left in the hands of jurists. So it wasn't the law of the state, and it had little bearing then on the administration of justice. The procedural rationalism of state law did not then become a feature of Islamic law, which was characterized by ethical considerations and procedural informality. He's going to come back to the importance of this in a moment. This informality, he said, went hand in hand with the dubious status of written documents. The decisive factor in establishing evidence in Islamic law is the oral testimony of a witness. Now, this is something we're going to see in a significant way when we turn to the case of Morocco, but for the moment, it's important to keep track of how a shift occurs in the status of documents versus oral testimony in the case of Iran. This stress on the witness emphasized, in turn, the personal character of justice in Islamic law without coordination between judges. This held up until the revolution in 1979, which inherited this formally rationalized political and juridical organization from the state that had preceded it, the state of the Shah, but that was now conquered. It was overtaken by the revolution, so that the state structures are in place. They have a particular character to them, this rationalized character, and this is what the revolutionaries kind of inherit and then have to figure out how they want to manage that, if they want to maintain any parts of it, if they want to incorporate or make a marriage between Islamic law and the rationalized system that already exists for law. And so it was this state that the Ayatollah Khomeini in particular sought to transform into a theocracy and thereby creating an Islamic judiciary, right? So that Islamic law would no longer be simply contained to jurists. It would now become the law of the land and function through the courts and through judges. So this implied not just a transformation of the state, but also, interestingly, of Islamic law. He says, the true Islamicization of the modern state into a Shiite theocracy required a drastic transformation of the Shiite sacred law. From being a jurist's law, it was transformed into the law of the state. Law finding, the typical activity of Islamic jurists, was to be replaced by legislation and codification. Shiite law was to be extended to cover public law fully. It was also to cover criminal justice. Shiite law then previously was informal in nature and would now be enforced through the rationalized mechanisms inherited from the state judiciary, so that the, to quote him, moral idealism of Shiite law had to give way, at least partly, to practical realism. Procedural informality had to yield to a formally rationalized bureaucratic court system. Its often unpractical personalism had to succumb to a more impersonal and efficient procedures involving much greater reliance on written documents and impersonal forms of evidence. So this is kind of a sea change in the character of Islamic law. A further implication is that the emphasis has shifted from normative witnessing, right, this sort of centerpiece of Islamic law up until now, to the knowledge of the judge in determining facts pertinent to the case, so that the place of the judge starts to become significant in a way that it, not to say that judges had been insignificant or that jurists had been insignificant before, but that it takes on a new kind of centrality. Earlier Iranian constitutions had borrowed very much from European models, especially the Belgian and French, but had maintained that the rule of law must rest on a foundation of sacred law in Islam. As such, they established constitutional law on a European constitutional template while maintaining a definitive place for Islamic law. Over time, and with revisions of the penal code, the role of sacred law in Sharia courts diminished, finally disappearing altogether from the civil and penal codes in 1939 and 1940. Right? So we can see this then perhaps as this kind of progressive incremental secularization of civil and penal codes over this time. After the revolution, Khomeini undertook to shrink the state dramatically, to desecularize the judiciary, bringing it under the authority of the hierarchy, which is priestly rule essentially, and reduce the jurisdiction of the state to matters, quote, beneath the dignity of Islam to concern itself with. Those are Khomeini's words. So these would be things like the economy and traffic regulation, right? The sort of menial stuff of everyday life that is beneath the dignity of Islam to concern itself with. The goal then was to leave only these menial day-to-day aspects of the management of the country to the legislature and executive. in the quest to transform Iran into a constitutionally Islamic state, the militant Shiite clerics, above all Khomeini, were deeply skeptical of Islamic modernists and nationalists, and wound up, in fact, persecuting them after the revolution, which cleared the path for the drafting of a constitution in the mold of the militant hierarchy. Ultimately, Khomeini placed the revision of the draft constitution under the authority of Shiite clerics, so ensuring a specifically Shiite constitution, with the demand that the revisions be undertaken from an Islamic perspective. Arjomand characterizes the resulting constitution like this. It places the judiciary system under the exclusive control of the hierarchy, with provision for extensive revision of the legal codes to render them Islamic. Furthermore, putting a doctrinally new emphasis on the continuous quality of imamate, endows the jurists as the representative of the hidden imam with supreme power over men and responsibility only to God. Finally, it sets up a clerically controlled council of guardians with inordinately extensive powers to represent the Shiite religious institution and to ensure that the legislative and executive branches of the state remain within the straitjacket tailored for it. That said, the legislature would consist of a popularly elected parliament, so this is the place of democracy within Iranian governance. The legislation it produced, however, would require the approval of the Council of Guardians, half of whom would be clerics. So there's a way then that the legislature is the product of popular sovereignty, of elections, but is still responsible to the Council of Guardians. And so the role of clerics remains paramount. Arjomand concludes, the clerical constitution makers of 1979 not only claimed the judicial prerogatives and supervisory power over legislation reserved for them in the Constitution of 1906 and 7 with a vengeance, but also added to it their novel clericalist claim, the right to rule on behalf of God. It is this last claim, embodied under the rubric of governance of the jurist into the Articles on Leadership, which makes the theocratic constitution of the Islamic Republic of Iran unique in the constitutional history of the Middle East. The ruling clerics take this uniqueness to mean that it is the only true Islamic constitution and, as such, is the universal blueprint for Islamic government. It's worth noting here, then, that the work of making the state Islamic came at the expense of making Islamic law substantially different too. We can get a sense of how different by looking at this next piece, a different setting in which Islam and law appear together, albeit in a distinctive way. So now we turn to Lawrence Rosen's Case Law and the Logic of Consequence. Rosen opens with the assertion that courts are rich if neglected for anthropological research, claiming that they may be as culturally characteristic of a broader society as any other institution we might study. So he takes case law in Morocco to show how in this society law pervades culture and culture informs law. He goes on to say, what, we may ask, does it mean to speak of a body of writing as constituting either a code-like set of rules or a system of particularizing case law when participants in the system have not themselves clearly calculated the respective importance of general rules and individual cases? Oh, I missed a step. Okay, so he focuses on this body of law called the Amal literature, which contains the opinions of Islamic judges on a range of issues. And it's from this that his question arises. The Amal writings date from the 15th to 17th century, and unlike the Quran or traditions concerning the Prophet's utterances and acts, they rest on judges' actual legal practice. The writings are heterogeneous, some composed as procedural guides for judges, so that would allow them to see how earlier jurists had considered the issues that they're now addressing, while other writings discuss the opinions in terms of the nature and range of acceptance of one approach over another. The notion of acceptance has an important place, he thinks, in Moroccan legal practices, and so advice on acceptance, rather than, say, something like consistency with previous cases, is valuable to judges. He says, faced with an issue not squarely covered by Quranic injunction, the Amal authors instructed judges to follow what is called the dominant opinion, the approach taken by most jurists in a given area and incorporated as such in most collections of judicial practice. However, a preferred approach, one based on what is socially desirable or customarily done, or even an isolated approach, one based on necessity, custom, or the approach of a well-known jurist, could be used in the place of the predominant approach. While no specific techniques were established for distinguishing precisely when each of these approaches could be invoked, much less for distinguishing cases by their facts, it is clear that the overall orientation implied by the Amal itself entwined with the added concepts of public welfare and custom. So this will become important, that the orientation of the readings is not to establishing something like a doctrinal set of precedents that judges feel obligated to consult, but rather they orient themselves to these notions of public welfare and custom. And so they help guide judges to consideration of those issues. Well, we'll see more of this as Rosen goes on. The point is not that Islamic law did not specify custom as a source of judicial decision-making, but rather that the opinions in the Amal served to legitimize local customs. Rosen makes a case that shared conventions, institutions, concepts, and tactics give shape and organization to social interaction, and he identifies socio-cultural constellations that are central to Moroccan life. First one is the importance of the individual. He says, for Moroccans, each individual stands at the center of a web of obligations and incorporates in his or her own set of characteristics and network of ties the features of social background and situated encounters by which they will become known to others. So interestingly, it's the individual, but the individual as caught in social relations. This is the model of individual that is important in Morocco, he says. So that the prioritization of the individual is not a prioritization of, say, one's inner states, one's psyche, one's private self, but stresses rather the person as the embodiment of traits and ties that are discernible and subject to incorporation into one's own realm of affiliations. This idea of the contextualized person, right, contextualized socially, is in turn connected to the Moroccan concept of truth, which is not something inherent in an act or an utterance, but exists as a process that brings otherwise neutral statements into the midst of human relationships and consequences. He says, if the situated individual and the validated utterance are two key ingredients of the Moroccan vision of reality, a third aspect is bound up in the idea of consequence, which we get from his title as well. Right? We know that he's going here. All right, consequence. In the Moroccan view, one can identify and assess a person, an utterance, or an act only by their consequences in the world of human relations. It's how a person impacts networks of obligations that factor into the way that others place and assess this individual. These three factors figure importantly in legal settings, Rosen tells us. One turns to the reliable witness. Okay, so the reliable witness. We've heard this phrase already from the case of Iran, from the tradition of Islamic law there that got revolutionized with the foundation of an Islamic republic. Okay, but here in Morocco, one turns to the reliable witness to verify the existence of a legally cognizable relationship. So a relationship that is understandable legally to the courts. It's visible to the courts as a legal issue. Because truth must be personal if it is to be consequential in the world of relations. Rosen sets up this kind of chain of connections. It looks like this. Who the witness is makes the assertion believable, or presumably not. The consequences a person may have in the world makes the weight of the claim accessible, so that you assess the weight of a claim relative to how consequential the person is in the world. The repercussions of one's acts comprise, not just reveal, qualities associated with background and character. And so, the social meaning of acts attaches to their embodiment in a specific person. The ability to trace the implications of these dynamics, then, is in social relations applies equally in the legal realm, right? So these are characteristics of social life. Rosen's thrust here, the point that he's trying to make, is that what has significance in the social realm has significance in the legal realm, and vice versa. So he's drawing a picture of these as knit together. In a sense, to understand one is to understand the other. So a case, say one of personal status or property, will appear before a judge in the form of a document. Now, this might make us think, oh yeah, this is familiar. We got this from the case of the Iranian Revolution, so maybe documents are not such a foreign thing to court after all. Maybe these cases are similar to one another. Rosen says not really. Why? Because the documents are the product of notaries, right? So these are court officials, let's say. And they are drawn from the oral testimony of reliable witnesses. This cements the place of oral testimony according to all of the dynamics that Rosen has just explained above, right? So that oral testimony then is still the centerpiece of the judicial proceeding. He explains, it is before such notaries, who always work in pairs, that a litigant will therefore appear, often with a significant number of fellow witnesses, to make assertions that can be assessed as true or false only when the court personnel, the notaries, have transformed mere utterances into legally cognizable claims. This format welds legal procedures to larger cultural patterns of thought and action, for instance, in the judge's careful determination of the social background of each of the parties at the outset of a case. That will have a bearing on the weight and verifiability of their testimony, of course. We've already seen that. And the judge's emphasis on local circumstances in judicial reasoning. Now, this, I think, is going to be something of a departure from what we see in Iran, right? So in Iran, things become impersonalized, rationalized, regularized, Not so in Morocco. He explains, indeed, it can be argued that unlike many complex legal systems that propel investigation and decision-making up to the higher reaches of legal order, in Morocco, the process of adjudication continually pushes matters down and away from the Qadi, the judge, down to the level where local custom and circumstance can become most significant. The use of multiple witnesses appearing before the notaries for certification of their oral claims, the frequent recourse to those who are expert in local matters, and a legal order in which the rules set down by authoritative sources are few and the scope for local practice is explicitly sanctioned, all contribute to the centrality of local customs and standards in the process of adjudication. Right? So again, maintaining this idea of adherence to the local rather than adherence to rationalized fixed principles or doctrines. Now we return to the Amal readings. The emphasis that judges will place on precedents and the guidance of the readings is not to legal principles then, but to legal outcomes, looking not for a way to maintain consistent adherence to doctrine or rules, but rather to results with their local consequences. He says, as one analyzes these collections, it becomes evident that the judicial choice among conflicting scholarly opinions is itself informed through the principle of the socially useful by the articulation of the court of local practices, right? So that the court is interested in articulating local practices with an eye towards the social usefulness of its judgments, of its findings. The judges don't focus then on principles or doctrines as such, or factual distinctions between cases, but on an assessment of consequences for people's networks of social ties. So that's quite a different orientation. What matters then, he says, is not the doctrinal meaning of any given case, but local significance. It can be argued, accordingly, that the primary goal of the Islamic law judge is to put people back into a position of negotiating their own arrangements within the broad bounds laid down by the canon of Islamic law. So in a way, the courts are trying to arrange things so that they can get out of the way and people can settle their affairs between themselves within this sort of broad rubric of Islamic law. In this way, Islamic law remains consistent with the relationships and assumptions of local society, which the court aims to reinforce, returning people to the general parameters of conduct rather than trying to govern the minutiae of daily life. So Rosen captures it like this. He says, what is, I believe, necessary in order to see more fully the role of the Amal literature and offer a more accurate interpretation of its role in the past, is to see how this pragmatic tool operated in the larger pragmatic context of Moroccan social and cultural life. Seen from this vantage, decisions in prior cases replicate a process of fact-finding and reasoning whose goal is to put litigants back in a position of negotiating their own lives. By constantly drawing the local into the ambit of the judicial, so drawing the local into the scene of the judicial reasoning of the court, essentially. And by emphasizing the perception of social utility as seen by a judge who, like others in society, can make his accepted view not by force alone, but by conducing acceptance by those affected by his judgment. The pattern of Islamic judicial decision-making replicates social practice and thereby adds legitimacy to judicial practice, so that the judicial practice gets its its authority, its legitimacy, by its ability to speak to local social practice. An implication of this judicial model is that it acts as a conservative force, not exclusively in terms of religious doctrine, but rather in terms of local customs and local social relations. It's worth then reflecting on how these two circumstances, Islamic law in Morocco and Iran, compare. So, for example, on the one hand, revolutionary imperatives to ensure conformity to doctrinaire readings and priority of Islam in law in the context of a constitutional republic led to substantial changes in judicial process around, for example, the authority of oral testimony and documents, informality versus rationalization and regularization, so on. We've been through that. Okay. On the other hand, the stress on the local and results, not the consistency of rule application, promotes conformity in Morocco, not entirely to religious doctrine, but to the local. And of course, there are other points on which we could contrast these, but this is the takeaway that I want from this then, is that there isn't a single relationship of Islam and law, but that the ways that these work out their relations in specific historical and social circumstances it gives us a sense of how it is that different communities will maintain the relevance of Islam for law and vice versa, but will practice it in distinctive ways given their own particular circumstances, let's say. Very good. That's it. Thank you.